And before we officially get started, I just wanted to go over a couple of housekeeping items. One, there are restrooms at the bottom of the stairs in the rotunda, as well as in the hallway directly to your left when you're leaving the auditorium. And the other main, very important item that I wanted to go over, questions. All of our panelists will be available for an hour at the end of our session for all of your questions. When you came in, there was a stack of index cards. You may have grabbed them. Feel free to grab them throughout the program. But to submit questions to our panelists, you can do so in two ways. One, if you are on Twitter, you can submit a question via hashtag ConConRI. That's hashtag ConConRI. Or I would just ask that you submit in writing on a postcard your question, including your name, and Diana will recognize you and read the question aloud, and you will be asked to stand if you have any follow-up questions, but we'll be able to take it from there. But all questions must first be submitted in writing. And throughout the entire program today, please feel free to submit your questions to me, or Melanie and Chad, could you raise your hands in the back? Melanie and Chad are our hardworking seniors here at Bryant University. You may also submit your questions to them or some of the other volunteers who might be here today. So with that, I'm just going to call to the podium Gary Sass, who is our founding director, and I hope you find today informative and helpful.
Thank you, Kate, and good morning. And I just briefly want to welcome you to Bryant's campus. Bryant University takes public service very seriously, and we appreciate you being here. Today's program is sponsored along with Roger Williams University Law School, Common Cause Rhode Island, the League of Women Voters, and the Hassenfeld Institute. And just briefly, the question of whether or not to authorize and call a constitutional convention will be on the ballot question at the November election. And I think your presence here indicates that the outcome of this referendum has the potential to go a long way to determine the future direction of the state, the kind of state that we'll have for decades. I know in this group, and as I travel around the state, there are strong arguments both for and against convening a convention. And very simply, the goal of today's conference is to try to shed some light, hopefully not fire, but light, as you hear from various points of view, and you hear from some national perspective on the important question of convening a constitutional convention. I don't think, we were talking last night, and I don't believe any state has had a constitutional convention since, I think we had the last one in 1986. I don't know, and the professors will enlighten us as to whether or not that's the case. The person that'll be facilitating the conference is Diana Hassel. Diana is the Associate Dean for Academic Affairs at the Roger Williams Law School. She's an expert in constitutional law and civil rights litigation. Previously, she served as Assistant U.S. Attorney in the Southern District of New York. So, Diane.
Well, welcome everyone, and I just want to say how pleased Roger Williams School of Law is to be involved in this critical issue for the state of Rhode Island this year. And what's going to happen first is John Marion, the Common Cause Executive Director, is going to give us some background on the relevant constitutional provisions in the Rhode Island Constitution and the history leading up to getting us to where we are now. John Marion has been the executive director of the Common Cause of Rhode Island for the past 5 years. And as I'm sure you know, Common Cause is a nonpartisan advocacy group focusing on open, ethical, accountable, and effective government. Prior to joining Common Cause, Marion was a lecturer at Indiana University and holds a BA with honors in political science and history from Binghamton University, and he also did graduate work in those same subjects at Indiana. So, John.
Good morning, everybody. My credentials are pretty thin compared to what you're going to hear later, but Diana, thank you for making the best of those. I think I know about 3/4 of the people in the audience, so it's nice to see you all this morning. I know we have a lot of people very interested in this question from a lot of different points of view. First, I just want to thank a few people. I want to thank Gary and Catherine and Bryant and the Hassenfeld Institute. They're the ones who provided the facility and the catering and everything for today. So we're very, very grateful for them doing that. I want to thank Michael Yolnowski, who I don't think you're going to see up on the stage today, the incoming dean at Roger Williams, who, along with Gary and myself, instigated this several months ago. I want to thank Jane Coster, who I don't know if she's in the room, from the President of League of Women Voters. Thank you to you, the League, who have supplied many of the volunteers for today. And then I want to thank the panelists, Professors Williams and Ladd, for coming up to Rhode Island on a beautiful spring day. And Steve Brown from the ACLU, Judge Flanders, who will be here a little bit later, and Jared Goldstein from the law school. And finally, Diana, I want to thank you for helping moderate today. Why are we here? So for the last year, I've talked to elected officials, I've talked to community leaders, some of you in the room, I've talked to citizens, friends of mine, and most of them have asked me two questions. They've said, is Common Cause going to support a constitutional convention, and can you tell me a little bit more what a convention would be like? So the answer to the first question is easy. Our organization, most of the board of which I think is in the audience, hasn't taken a position yet. We're going to wait and see what happens with this General Assembly session. But historically, in the last two cycles, we've opposed conventions, or the convention question, along with many of the groups represented today. Best I can tell, and there may be people in the room who have the history better than I, in 1984, the first time this question went on the ballot, we did support it. And there was a convention, as we know, in 1986. The second question is really why we're here today. I felt, and I think other people have felt, that there isn't enough information out there about what a convention would look like, what issues might arise at a convention, what the election of the delegates might look like. While numerous groups have already started staking out positions, so we know Operation Clean Government is for a convention, the Secular Humanists, the ACLU, other groups are against a convention. There hasn't been a public forum to really talk about the mechanics of a convention yet. So we thought that this would be a good time to pause and look at that and look at the issues that might arise. Just walking in, I talked to somebody from RIC who said they're planning on trying to have more forums in the fall. So I think this will be the first or second of many forums on this topic. So what I want to talk about is a little bit today to start us off is the November ballot question, and if that passes, what the statute that will have to be passed by the General Assembly is going to look like, and that statute is going to authorize the election of delegates. Then I'm going to talk a little bit about the nature of the special election that would be held to select those delegates, and then finally a little bit about the structure of an actual convention, how they might conduct their business, and finally some of the issues that we might see at a convention. So let's start with Article 14, Section 2 of the Constitution. I put them on the table out there. I got here a little late, so you all might not have them, but there was a one-page sheet that on one side had the constitutional language. That's the reason we're here. This section of the Constitution was put into the Constitution in 1974. Patrick Conley, who many of you have heard speak in other venues, claims ownership and authorship of that. And it replaced a rather cumbersome process that we had in our prior Constitution for amending the Constitution. And it replaced it with a pretty clean and understandable couple of ways to amend our Constitution. I'm not going to talk about Section 1. Section 1 deals with how the legislature puts a question on. But I'm going to talk about Section 2, and it begins with, the General Assembly, by a vote of a majority of the members elected to each House, may at any general election submit the question, shall there be a convention to amend or revise the Constitution, to the qualified electors of the state. If the question be not submitted to the people at some time during any period of 10 years, the Secretary of State shall submit it at the next general election following said period. So to the best of my knowledge, the General Assembly has never passed the necessary resolutions to put it on the ballot. So it's come down to the Secretary of State putting it on the ballot every 10 years. We certainly know that the General Assembly has never put it on in between the 10-year period. The second sentence, beginning with, if the question be not submitted, has a little bit of a muddled history. In 2013, as I said, Dr. Conley, who authored this, testified before the Rhode Island Senate that it was his interpretation that meant the question goes on the ballot in 2016, and that we're a little premature here in March of 2014. His interpretation was that the Secretary of State puts it on only if the legislature doesn't put it on in a 10-year period. They put it on at the next election. However, Secretary of State Mullis, our current Secretary of State, has decided to follow the precedent set by Kathleen Connell in 1994 as interpreting that sentence to mean that the question goes on this year. And I don't want to dwell on that because it's settled. Our Secretary of State is on the record as saying the question's going to be on the ballot this November. However, it's worth noting that the Rhode Island Senate, and I see Senator Hodgson here, has already gone ahead and passed their resolution that would put this on the ballot. There's no indication the House is going to do it, certainly not after the events of the last week. I wouldn't expect to see the House act on this very hastily. So we know the question is going to be on the ballot. So the next section of Article 2, or Article 14, Section 2 reads, prior to a vote by the qualified electors on the holding of a convention, the General Assembly or the governor, if the General Assembly fails to act, shall provide for a bipartisan preparatory commission to assemble information on constitutional questions for the electors. Okay, so this is the next phase. The General Assembly has the option of creating a commission. If the General Assembly doesn't create the commission, the governor can create the commission. In the last 3 cycles that this has happened, we've seen it work both ways. So the General Assembly has in the past created a commission. In 1984 and 2004, those commissions were constituted and met. In 1994, the General Assembly failed to act, and the governor failed to act until literally the day before the election. Bruce Sunland issued an executive order creating the commission. So he went through he went through with that, although obviously the commission never met and made any recommendations or assembled any information. And the Rhode Island Senate, should be noted, has also passed a resolution to create that commission, and I probably don't expect that the House will anytime soon. But given that our current governor, Lincoln Chafee, has stated his support for a convention, I would expect him likely to fulfill his constitutional duty under that section if the House does fail to act. A couple of interesting things. One, Gary Sass, who spoke earlier, I believe holds the record as the only person ever to be appointed to all 3 of those commissions. So if there's a Hall of Fame of constitutional preparatory commissions, Gary is in that Hall of Fame. The 1984 commission held 5 public hearings around the state. Interestingly, they endorsed a convention. I think there are members of that commission here today. They took the affirmative step of endorsing having a convention. They went through a number of possible changes to the Constitution, but they didn't endorse any of those changes. In 2004, the commission, again, it held 6 public hearings. They claim to have heard from 62 members of the public. They did not take a position on whether there should be a convention. But like the 84 commission, they identified a number of issues, including some that were repeated from 20 years prior, that they believed would be raised if a convention took place. They also did something else which was interesting and I think helpful, which is they tried to come at the question of how much a convention would cost. And I think there'll be questions about that today. And they came to an estimate of approximately $2 million. And so this was 10 years ago. So as I said, I expect the commission will be created. I expect they'll meet and produce a report. But one thing to keep in mind, if you look back at the 1984 commission report, and I'm going to try to put both of these reports up on the Common Cause website, and they're fairly brief, they're 10 pages each, they're worth reading. Many of the issues raised in the 84 commission report didn't subsequently come out of the 86 convention. So maybe we shouldn't put too much weight into these preparatory commission reports. So as I've said, the question has come before the voters 3 times since the 1974 changes to the Constitution. In 1984, as we know, it passed. It got 53.8% of the votes. In 1994, it was defeated. It only received 40.5% of the votes. And in 2004, the most recent time it was on the ballot, it received 48% of the votes. So it lost by a fairly slim margin. What are the chances this time? I've been asked. I know, and I'm sure other folks here have been asked. The only thing we have to go on is a January 2013 poll by Public Policy Polling, where they did, I believe, a sample of roughly 500 Rhode Islanders, and it came up with 40% of Rhode Islanders supporting, 25% opposing, and 35% undecided. And really, that poll is another reason why we're here today. There's a lot of people who are undecided about this question so far, and we think public education is an important part of helping those people. So next, what I want to talk about is a little bit about what happens if the vote occurs, or passes, if the question passes. So if you move on in Article 14, Section 2, it says, if a majority of the electors voting at such election on said question shall vote to hold a convention, the General Assembly at its next session shall provide by law for the election of delegates to such convention. The number of delegates shall be equal to the number of members of the House of Representatives and shall be apportioned in the same manner as the members of the House of Representatives. So obviously our only experience with this section is in 1985. And what there's one big difference that many of you know from 1985 to 2014, which is that we've downsized the legislature. So we've gone from 100 House districts to 75 House districts. And that will obviously have some impact on what a convention would look like. So in 1985, on June 27th, 1985, an authorizing statute went into effect without the governor's signature to form the convention itself. And we can get quite a bit of information, particularly about the election of delegates, from what that statute said. Interestingly, it said that it would be a nonpartisan election of delegates. The preparatory commission in 2004 concluded that it doesn't have to be a nonpartisan election of delegates. It could be done on a partisan basis. But the only example we have in Rhode Island history since 1974 is a nonpartisan election. It's worth noting the prior conventions, prior to 1974, I believe 10 prior conventions were elected on a partisan basis. So in 1985, that election was an anomaly in our constitutional history. The statute went on to talk about some of the parameters for that election. It said that all applicable election laws, including voter registration and campaign finance laws, applied to the election of delegates. I was unable this week to find campaign finance records from 1985. They may exist, but I wasn't able to get a hold of them. So we don't know how much the delegates raised and spent, although that should be a question that can be answered. I do know that under current Rhode Island election law, as many of you know, there are no restrictions on spending by a candidate for office, but there are restrictions on how much they can raise, $1,000 a year per contributor as a maximum. A couple of other quick things. The ballot order is determined by lots drawn by the Secretary of State. The delegates, if a delegate cannot serve, the next highest vote getter will serve in their place. And candidates only need 50 qualified signatures to get on the ballot. So it's a fairly low threshold. So what did we see happen in 1985? And by the way, the election occurred in November of 1985. It was an off-year election held concurrent with some municipal elections in the state. But in most communities, this was the only election that occurred. 558 people ran, so that averages out right to 5.5 people per district. There were 96,536 votes cast, so you had an average of a little under 1,000 voters per district. How does this compare? Well, I went and looked at the 1986 general election and the ballots cast for members of the House in 1986. There were 273,502 votes cast just a year later in the general election, so 2,735 votes per district, so roughly 3 times the number of voters in a regular election. So it was a very low turnout election in 1985, more comparable to a primary election. What did the delegates who were selected look like? Well, unfortunately, we don't have any demographic information. The only thing I could glean from the list was that 21 of the 100 delegates were women. So that's something of note. And that many of the delegates have gone on to lead very public lives in the public service. So a couple of notable names. Governors Bruce Sunland and current Governor Lincoln Chafee were delegates. Congressman Jim Langevin was the secretary of the convention. Former Rhode Island Supreme Court Chief Justice Frank Williams, and then many members later of the General Assembly, including current Senate Majority Whip Mary Ellen Goodwin, were delegates, as well as other people involved in civic life, not through elective office in the state. A couple notable names of folks who ran but did not succeed, current Senate President Paiva Weed, and I assume when I looked in the records, Judge Flanders, that you ran? No, you didn't. There was a Robert Flanders who ran and did not succeed. So there are 2 Robert Flanders in this state. Before moving on, it says, no revision or amendment of this Constitution agreed upon by such convention shall take effect until the same has been submitted to the electors and approved by a majority of those voting thereon. So as many of you know, in 1986, when the convention concluded, it delivered 14 questions that were on the 1986 ballot, 8 of which passed. So let me briefly look at the convention itself. The same statute that authorized the special election called the convention for January 6th, 1986, and stated that the convention would be subject to the Access to Public Records Act as well as the Open Meetings Act, unlike the General Assembly. It gave them the power to ask the Supreme Court for advisory opinions, and it gave them subpoena power at the vote of a quarter of the delegates. So as I said, it was called to order on January 6th. It organized itself into 6 substantive committees and 3 organizational committees. The substantive committees included one on citizens' rights, one on ethics in government, one on the executive branch and independent agencies, one on the General Assembly and elections, one on the judiciary, and one on local government. The organizational committees included a public information committee, a rules committee, and an important style and drafting committee. After they organized themselves, they did a bit of a road show. They went around the state, had 11 public hearings around the state in the month of February and early March, which saw over 1,000 people testify. They set an early April deadline for the delegates to submit resolutions, and they saw 322 resolutions proposed. You can go, I won't go through them, but in the archives, there are copies of the resolutions and lists of the resolutions that are very useful to look through. They represented, some issues of the day, right? Divestiture against the apartheid government in South Africa, but some timeless issues of constitutional law too. The 6 substantive committees held 111 meetings, 34 public hearings, and they heard from a wide variety of groups, including our group. They produced 32 policy reports, 22 legal reports. They had a somewhat significant staff. They operated, interestingly, on a very similar schedule to the General Assembly. So the bulk of their business was done between January 26th and January 6th and June 26th, the traditional end of the legislative session, that last week in June. And I would, all of this is gathered from the state archives and that have the records of the convention, which are also held at Providence College and are worth going through. There were 10 plenary sessions, so once the committees reported out, and they reported out, they had 43 committee reports and 24 resolutions. Those plenary sessions winnowed it down to 14 ballot questions, which were put on the November ballot. As I mentioned earlier, there was a cost to this. The cost of the 1986 convention in 1986 dollars was $891,000. So putting that in today's dollars, that's $1.8 million. So what did they put on the ballot? Well, they put 14 questions. They put a rewrite of the present Constitution, which was a neutral rewrite, taking the 44 amendments that had been made in the prior 150 years and adding gender-neutral language and other things. They put that was approved. They put a question on judicial selection to create a merit selection system of judges. That was rejected. They put a question on legislative pay to increase legislative pay and make some other changes. That was rejected. They put a question on to give the general officers four-year terms of office and allow for recall. That was rejected. They put a system of voter initiative, and that was actually a much discussed. There was actually a subcommittee of the committee to look at that question, and that was rejected. They created the Rhode Island Ethics Commission. That was approved. They gave the governor a role in the state budget process and created, made the Speaker of the House third in line for succession, and that was approved. There was a catch-all amendment dealing with a number of civil liberties issues that was approved. There was an environmental and shore use amendment that expanded the power of the state and local governments to protect the rights of fishery and privileges of the shore, which was approved. There was a question on felon office holding and voting that was approved. There was a question on libraries and making the General Assembly responsible for providing for libraries, approved. There was a question about denying bail in the cases of some drug crimes, which was approved. There was a question about home rule, strengthening home rule in the state, which was rejected. And there was, most famously, a right to life question that would have limited access to abortion services that was rejected. The convention came back together on December 4th and ratified the results of the election. So trying to get a handle on what might happen if there's a convention in 2016, we went through and figured the best way to look at it was what issues have come before the General Assembly in the last 10 years. So we went through every resolution in the last 10 years introduced to amend the state constitution. And there was an article, or there was a piece out on the table that we produced that showed there were 157 amendments in the last 10 years on 33 unique topics. They clustered around areas of legislative and executive reform, although interestingly, not a single one on judicial reform, as well as fiscal issues, and a sprinkling of other topics, including civil rights. So I would urge you to look through that document because I think that's the best indication of maybe what is going to be coming up in a convention. I'm getting the wind up signal. I'm just going to mention that in the last 10 years, there have been 6 questions put by the General Assembly to amend the Constitution on casinos, on changing the state's name, on helping the rainy day fund of the state. And they've met with mixed results. And I guess in the interest of time, I'm going to try to wrap up there. I hope this has been helpful. I hope this answers the basic question of what one of these things is going to look like, what the question is going to look like, in November, what the special election of the delegates would look like, and what a convention broadly would look like. Unfortunately, there aren't any great, I wish I could say, go read this book. There's a great narrative of what happened in 1984 through 1986. There isn't a single volume that tells that story. So I hope this has been helpful. Now we'll turn it over to the real experts from Rutgers who are going to try to put this a little bit in comparative perspective. So thank you very much.
So as John mentioned, we're going to now hear from our national experts on state constitutional law. The first one is Professor Williams, who's a nationally recognized authority on constitutional law. He's a distinguished professor of law at Rutgers, University of Camden, and also the associate director of the Center for State Constitutional Studies at Rutgers. He's the author of dozens of articles and numerous books on state constitutional law, including State Constitutional Law, Cases and Materials, the New Jersey State Constitution, a reference guide, legislative law and statutory interpretation, and the law of American state constitutions. Professor Williams received his BA from Florida State University, his JD from the University of Florida, and LLM degrees from Columbia University and New York University. Our second expert is Professor Alan Tarr. He's also a distinguished professor of political science at Rutgers University and the director of the Center for State Constitutional Studies. The Center for State Constitutional Studies is an interdisciplinary institute dedicated to promoting public understanding of state constitutions and subnational international constitutions. Professor Tarr is also the author of several books, including American Constitutional Law, Judicial Process and Judicial Policymaking, Understanding State Constitutions. He received his BA from Holy Cross and an MS and PhD from the University of Chicago.
Well, thank you very much. I want to thank the organizers for inviting us. As you can tell, we're really interested in these processes, and I may say it's great to be back in Rhode Island and on this beautiful university campus. It's my first time here, so I'm very pleased to be here. What I want to try to do is step back a little bit and say to people who are going to decide whether to vote to have a constitutional convention or not, discuss for a little bit, well, what are state constitutions? And try to lay a groundwork for what might happen at a state constitutional convention with respect to these unique documents. So as you consider this question, I think one has to, as I said, step back and think, well, what are we dealing with here? And many people think, well, the state constitution, it's just a little miniature version of the United States Constitution. And that's a big mistake. There's a real paradox in this country that state constitutions are what I call low visibility constitutions, and they're pretty obscure to people. Maybe a little more knowledge here in a state like Rhode Island that has a regular look at the state constitution. But the paradox is that people in this country actually know a fair amount about the United States Constitution, but they have no opportunity to influence it in any way. The United States Constitution is completely inaccessible to us as citizens. It's only been amended, however many times, 27 times in all these years. It's really unrealistic to think of any textual change in the United States Constitution. Interestingly, state constitutions are low visibility or obscure state constitutions, but yet we as citizens actually do have an opportunity to access state constitutions and have some influence over their content. Exhibit A, what you're talking about here in Rhode Island. So it's a very odd situation. Everybody knows about the federal Constitution, but can't do anything about it. Very few people know anything about the state constitutions, but they could do something about them. So let me try to describe why, in 5 or 6 points, why state constitutions are really quite different from the United States Constitution and are really not just little versions of that more familiar Constitution. First, and most people don't realize this, the state constitutions predated the United States Constitution. But on the East Coast, at the time of the Revolution, the newly independent states rushed to draft their own constitutions. Now, Rhode Island did not do so, but I live and teach in New Jersey. Our state constitution dates from July 2nd, 1776. And there were 4 or 5 other states right away in 1776 with their own constitutions. These then served as the actual models for the United States Constitution 11 years later. Many people don't realize that. The first great distinguishing factor is that the origin or the pedigree of state constitutions is quite different from the United States Constitution. Again, Exhibit A here in Rhode Island. The people vote on the adoption of state constitutions or revisions of state constitutions or amendments to state constitutions, and even on certain policy matters such as gambling, assumption of debt, what have you. None of us ever voted on the United States Constitution. You remember that was submitted to ratifying conventions that made the decision. Even now, amendments, rare as they are submitted to the state legislatures, not to us as voters. So it turns out, actually, the state constitutions are much more democratic than the United States Constitution. And again, we see this played out quite explicitly right here in Rhode Island, as well as a lot of other states. Interestingly, too, the state constitutions reflect, or they have the fingerprints of alternative voices. You remember that the United States Constitution was the product of 55 pretty old, pretty white men sitting in Philadelphia. Yes, the 14th Amendment and the post-Civil War amendments did have involvement of African Americans and maybe a few women. I'm not sure about that, Alan. But the state constitutions do reflect the attitudes of, you just heard 20% of your Constitutional Convention in 1986 was women. Our 1947 Constitutional Convention in New Jersey was 10% women. We've seen African Americans, Hispanics, young people. I think if you have a Constitutional Convention here, you'll probably see members of the LGBT community, all sorts of voices that I call alternative to what we've seen in the United States Constitution's slow evolution, and you know, this could make a very different sort of reflection of the attitudes of the citizens here and in other states. The second main distinction between state constitutions and the more familiar United States Constitution is the state constitutions are much more flexible, obviously. They're malleable. They have permitted the states to operate their government, their rights, and the matters that they've constitutionalized in a trial and error process that's just simply not available at the federal level. Again, the United States Constitution is for all intents and purposes impossible to amend. so that the states have been able to keep up with changing times, not as well as a lot of people want sometimes, but the states have been able to keep up with changing ideas about governmental institutions, about rights, and again, about matters that should be entrenched in the Constitution rather than left to ordinary lawmaking. The state constitutions reflect these matters, such as item veto for governors, which I take it you still don't have here in Rhode Island. 46 or 47 states have that now. That's no one ever thought about that and almost every sitting president would kill to have the item veto, particularly former governors who reached the presidency after serving in a governorship that has the item veto. Likely impossible at the federal level. Term limits, a more modern idea about the structure of government, have been able to, whether you agree with that or not, they've been able to be inserted into various state constitutions because the state constitutions are able to evolve. Limitations on legislative procedure, the blocking of enactment of laws on multiple subjects, omnibus laws, which we see at the federal level because there's no limit on how Congress can legislate. In the states, we see very substantial limitations on this process. In the rights area, states have adopted equal rights amendments, textual privacy amendments, and all these sorts of things that can actually be done at the state level. Again, virtually impossible at the federal level, as those who worked on the federal ERA came to realize. Third major distinction is that the legal and political function of state constitutions is actually quite different from the legal and political function of the United States Constitution. Again, they're both called constitutions, so most people in our country think, well, there's the big one, and then there's all these 50 little ones that are kind of like it. Wrong. And you'll remember this from civics if you think about it, and a lot of you already know this, I know. The U.S. Constitution, of course, was drawn up by representatives of the states, and the United States government operates under an enumeration or a grant of fairly specific powers. Now, yes, the United States Supreme Court has expanded on these over the years, but you'll remember the United States government can regulate interstate commerce. It can provide for the national defense. It can provide for post offices and post roads and some other stuff. And that's it. Remember, everything else was left to the states. And this is even expressed in the 10th Amendment to the U.S. Constitution. So everything else about how government operates is left to the states. So when you think in Rhode Island, should we pass a Landlord-Tenant Act? Should we pass a land registration statute? Should we pass a criminal code? You don't have to look to your Constitution to see if that's possible. Where do we get the authority to do that? No, all of this power was left to the states. We call it residual plenary power. So the main legal and political function of the state constitutions is to limit that power. Okay? So this is a little bit of an oversimplified distinction, but it's quite powerful. The major function of the United States Constitution in terms of government power, certainly there's the Bill of Rights that limits the federal government, but the main function of the federal Constitution is to grant or enumerate fairly specific limited power. The main function of state constitutions is to restrict or limit this plenary, residual, quite broad power. And this really influences judicial interpretation of state constitutions by contrast to the federal Constitution. Remember last year, could the U.S. Congress pass the Affordable Health Care Act? And that was a question about power, enumerated competency, the comparative lawyers call it. And remember, it turned out the U.S. Congress by a 5-4 vote, was not allowed to do that under the power to regulate interstate commerce. Turned out it was allowed to do it under the taxing power. Big surprise to a lot of us who watched that case. But that was a case about what can the government do. The cases in the states are what can the government not do. Okay, so it's really the quite opposite sort of legal and political function. As a result of this, the U.S. Constitution is an incomplete document. It's an incomplete governing document. It doesn't provide for how the states govern themselves, how the states structure their governmental institutions, how the states provide for rights and such. There's very little in the U.S. Constitution about how states operate. And if we didn't have the state constitutions to fill in all of those gaps, we wouldn't have a constitutional system in our country. So really, of course, American constitutionalism includes both of these different kinds of constitutions that are quite different from each other. A couple more quick points. The form, what the constitutions look like, is quite different. You know, the revered federal constitution, it's brief, it's endured for all these years, very few amendments. Gosh, isn't this what a constitution should look like? Well, maybe a constitution that grants or enumerates specific powers should look like that. How many words does it take to say that the U.S. government can regulate interstate commerce? Not very many words, it turns out. State constitutions, by contrast, are longer, much longer. The Alabama Constitution's that thick, outrageous, but nobody wants to change it down there. There's more there in state constitutions. More is constitutionalized in the states than in the United States government. And to some extent that makes sense because there's more government authority in the states than there is in the U.S. government. This surprises people because people think of the U.S. government as being so all-powerful. And it is true that when the U.S. government uses the spending power, it can affect all kinds of state matters like education and health care and all those sorts of things. But so not only do the state constitutions deal with a much wider range of governmental authority, they also are much easier to amend. Again, Exhibit A, Rhode Island. And as a consequence of that, the state constitutions are layered with the concerns of each generation or even every several generations. It just depends how often the constitutions are revised or replaced, how long they endure. But they don't endure that long. Louisiana's had 11 state constitutions. In New Jersey, we've only had 3. I'm from Florida originally. Maybe we've had 4. How many have we had at the national level? 1. Okay. So you see this reflection in the state constitutions of the concerns of the generations that we've seen. Next, the state constitutions are different in origin, function, form, and now as well they're different in quality. They're different in respect to what's in them. Yes, of course, state constitutions structure government institutions just like the U.S. Constitution does. Yes, state constitutions have declarations or bills of rights, not just like, but similar to what the United States Constitution has. But yet they have long articles, and I haven't checked Rhode Island, but most states have long articles on taxation, on education. Out west, water rights, very important. Water's becoming more important than money out west. Environmental provisions, corporate regulation. Notice all of these things could be left to ordinary lawmaking by the legislature. But what we've seen over the 225 years or so in the states is that many of those policy matters have been entrenched in the state constitution over the years. Again, succeeding generations' concerns. Why? Because they don't trust the legislature with respect to any legislators who are here. By the way, I got interested in this stuff because after I graduated from Florida State, I worked in the state legislature for the summer before I went to law school back in the midst of history, 1967. And that summer they rewrote the state constitution. And all of the same kinds of concerns came in. And so I got to see up close that sort of process. And here I am so many years later. But so the state constitutions, again, have the different qualities because they include all of these policy matters that operate to limit the legislature. As well, we see positive rights, social and welfare rights that are quite different from the U.S. Constitution's negative rights, okay? And I just learned, apparently, since 1986, you in Rhode Island have a right to libraries. Fantastic. That mandates the legislature to do something with libraries. I don't know what would happen if the legislature didn't do that, but studies have shown that nationally about 40% of what is in state constitutions are policy matters that certainly could be you wouldn't need anything in a state constitution dealing with taxation. You wouldn't need this is within the reserved plenary authority of the states, primarily state legislature. You wouldn't need anything about education. You wouldn't need anything about corporations to enable the state legislature to make policy with respect to those matters. But again, that would scare the daylights out of most people. Gambling is another good example. Here in Rhode Island, in our state of New Jersey, legislature's not going to be allowed to deal with gambling. Why? Because of the decisions of these succeeding generations. So again, ease of change leads to a lot of these things. Some people think the state constitutions are too easy to change and therefore are really not constitutional. Some people think that state constitutions are too long, they're too detailed, and therefore they're not really constitutional. And what these people are doing is comparing state constitutions to the model that all of us know, which is the United States Constitution. I want to suggest that's a big mistake, and as you go forward in trying to determine whether to have a convention to look at your state constitution, and if you do have a convention, to look at what functions and qualities a state constitution has by contrast to the U.S. Constitution, that this is the way you'll think about your state constitution. They're real constitutions. They have constitutional authority in our American system, but they're different from the United States Constitution, and they ought to be different. So I want to call on my colleague Alan Tarr, from whom I've learned everything I know. I'm sorry, Alan, I forgot one point. I just looked down at my notes, excuse me. What you're going to see, never mind, and I still have a minute. John mentioned this, that state constitution making, the notion that state constitutions can be a tool for policy making, that notion has been discovered by national groups. And we saw it in the example in 1986 of divestiture in South Africa. That's not going to, if you have a constitutional convention now, that's not going to come up. That's history, okay? But what's happened is a lot of the national questions that we think of across the country sprout up in state constitutional change processes. Abortion, the questions about abortion. you know full well the questions about same-sex marriage. These are national questions. Gay rights. Now, more recently, animal rights. In Florida, we have a long provision in the Constitution that says how farmers have to treat pregnant pigs. Okay, I like pregnant pigs. But and this is a national movement. It's not just a Florida movement, countered by hunters, hunting rights, that kind of thing, and fishing rights. Now we've got anti-Islamic law provisions in Oklahoma and other states, anti-international law, trying to limit state courts from relying on those. So anti-affirmative action, which tends to be a national issue before the United States Supreme Court now with the Michigan constitutional anti-affirmative action provision. The last election, and then I'll yield the floor. I still think I have a minute, if my watch is right. Darn it. This last go-around, you may have noticed there were a number of amendments proposed in the states that said nobody in our state shall be required to buy health care coverage. This is a national debate, of course. Other provisions, nobody shall be required to vote for a union without a secret ballot. This was an attempt to deal with the pending national legislation on it never passed, but on labor rights. So this go around, it's the issues of the day, together with central questions about how your government is structured and such, that will come up in a constitutional convention. So, sorry, Alan, come on.
About what you're doing in this particular state and make, we hope, a bit. So I'm delighted to be here and delighted to be talking to you about state constitutions. Neither Bob nor I are experts on Rhode Island Constitution. Think about what you're doing in this particular state and make, we hope, a better decision by virtue of attending forums such as this. Let me begin by noting what we're doing here today. We're sitting here discussing whether to call a convention to amend or replace the Rhode Island Constitution. Yet most of us could never imagine ourselves at a similar conference deciding whether or not to amend or jettison the federal Constitution. It's a rather striking contrast, but it isn't hard to understand why. As Bob mentioned, most of us revere the U.S. Constitution. We have a National Constitution Center in Philadelphia celebrating the founders, and most of us think we couldn't do a very good job of improving on their handiwork. But somehow we don't feel the same reverence, the same attachment to our state constitutions, whether you're talking by state of New Jersey or yours of Rhode Island. Rather, we think of these as rather prosaic documents, can-do documents, things which are going to enable us to structure our government that will serve us better, things that are going to enable us to have a better state. In another sense, of course, we're not here of our own volition. We're here because the Rhode Island Constitution specifies in Article 14 that every 10 years, if a convention question has not been on the ballot, every 10 years, it will be placed on the ballot by the Secretary of State. This is not totally distinctive to Rhode Island. 13 other states have a similar sort of provision. Article 14 further mandates that if a simple majority of those voting on the question favors a convention, then a convention must be held. Again, think of the contrast with Article 5 of the federal Constitution. In order to get a convention at the national level, you need the concurrence of 2/3 of the state legislatures, something that's never happened. And so we have the single convention at the national level. We have multiple conventions in the various states. This requirement of a periodic popular vote is a relatively recent addition to the Rhode Island Constitution. It was imposed by constitutional amendment in 1973. In fact, neither of Rhode Island's earlier constitutions, at least at the time that they were drafted, had such a requirement. Indeed, neither of those constitutions expressly authorized the legislature to call a convention at all. Indeed, in the late 19th century, the Rhode Island Supreme Court said the state legislature cannot call a constitutional convention, a decision that wasn't overturned in Rhode Island until 1935. Adding this requirement of a periodic vote seems to me a very wise decision, because it doesn't create an obligation so much as it creates an opportunity. I wish we had the similar provision in my own state. For the requirement has the effect of forcing or encouraging the citizens of the state to think seriously about their government, what's right, what's wrong, and what can be done to improve it. Now, this may all sound very familiar to you as citizens of the state, but a moment's reflection reveals how unusual this is. Compare Rhode Island's experience with constitutional change at the national level. Rhode Island's had 8 constitutional conventions. The federal government, of course, has had only one, and Rhode Island didn't even bother to attend. Rhode Island's current constitution, ratified in 1986, has been amended with more frequency than the federal constitution. Federal constitution, 27 amendments. If you take out the Bill of Rights, which is sort of part and parcel of the original founding, that's one amendment about every 13 years. Very difficult to change. On the other hand, if one compares Rhode Island's experience with that of other states, the disparities may not seem so stark. Most states have had multiple constitutions. Rhode Island's had 3. The total number of state constitutions, 144. So it's right in the middle of the pack here. Louisiana, as Bob mentioned, had the dubious distinction of having 12 constitutions. It's sort of a tradition there, was like Mardi Gras. And state constitutions are modified, amended frequently. Alabama's 1901 Constitution has been amended over 900 times. I was down there talking to them, and they said that our Constitution looks like Moby Dick with a couple whaling chapters taken out. California's Constitution, almost 500 times. What we really have then is sort of 2 different constitutional traditions. At the national level, we value stability and continuity. At the state level, we value change and experimentation. This reflects actually a conflict of views, if you will, at the very point of the founding. James Madison emphasized the importance of constitutional stability and the dangers of frequent change, interesting the people too much in these highly controversial issues. In the states, however, we look not to Madison, but we look to Thomas Jefferson. Jefferson thought that it was important to get people involved, participating in resolving constitutional disputes, both to ensure that constitutional principles were adhered to, the people would guard the constitutional principles, and also to allow growth in response to changes in circumstance and with regard to changes in attitude. Jefferson said, "Why would I want to wear as an adult the coat that I wore as a young boy? It won't fit. The situation has changed, and we must adapt accordingly." In fact, this idea of a periodic vote on whether to have a convention is something which Jefferson himself had originated. Now, of course, every state has its own distinctive constitutional history. Rhode Island, for example, unlike any other state, for a while had a constitution that wasn't a constitution, if you will. After independence, Rhode Island retained its 1663 charter from the king as a constitution. By the time it was finally replaced in 1843, it had served as the fundamental law of the state, or of Rhode Island, pre-state and state, for 180 years. In addition, no other state has simultaneously had two constitutions with two competing governments, but courtesy of the Dorr Rebellion or the Dorr War, depending on which historian you talk to, you have the citizens of the state, stymied by the legislature in their efforts to hold a convention, held an extra-legal convention. They drafted a constitution, they elected a governor and a legislature, and so you had simultaneously two legislatures and two governors operating in the state. If you're one of these people who thinks that one government is more than enough, imagine this. What that extra legal convention did, however, is sort of interesting because it also points to the way in which constitutional conventions can promote change. What happens, eventually the Dorr Constitution, the so-called People's Constitution, is not recognized by the federal government, but the threat of this was sufficient to get the legislature in 1843 to call a convention and to meet most of the concerns that spurred the Dorr Rebellion. Of course, these are merely historical examples. For most of its history, Rhode Island has had other distinctive features. State legislature selecting the state judges until relatively recently. Until 1909, there was no gubernatorial veto at all, and of course, as you all know, there's no item veto even now. But what's important here is not whether Rhode Island is distinctive or not, but the fact that you get to make your own choices. And so what I'm going to talk about primarily is the sort of choices that are involved, the sort of process. John Marion already talked about this in some detail, and in some instances I may be repeating him. It's always the disadvantage of speaking last. But the process by which things are done. Rhode Island, like all other states, have chosen procedures for constitutional change that give great power to the people. First of all, the people by majority vote get to choose whether or not to have a convention, and they may well decide not to pursue constitutional reform. Thus, although Rhode Island has had 8 constitutional conventions, voters have at times rejected convention calls, most recently in 1994 and 2004. The people also choose the delegates. The people also get to ratify or reject the convention's handiwork. And Rhode Islanders, again, have used this opportunity to make significant choices. Thus, in 1898 and 1899, Rhode Island voters voted down a series of amendments proposed by a constitutional convention. And more recently, in 1968, they rejected a proposed constitution by a 4-to-1 margin. Maybe there's an ornery streak in the state. Note that in making these choices, the people are acting directly, not relying on their representatives in the General Assembly. Put differently, the government does not control popular access to the fundamental law. This is true in other states as well. As I mentioned, 13 other states have joined with Rhode Island in creating a periodic popular vote on whether to hold a convention. 18 additional states have sought to ensure popular control over constitutional change by adopting constitutional initiative for proposing amendments. 2 states allow the voters to call for a constitutional convention via constitutional initiative. Yet the alternative that Rhode Island has chosen may be the wisest course. At least in part, this is because of the indirect effects that the periodic popular vote can have. Those in power often oppose a constitutional convention because they fear that constitutional change may undermine their positions or reduce their power. The impending periodic vote on a convention, then, creates an incentive for those who hold authority to address problems that might otherwise encourage voters to vote for a convention. In that sense, then, one sometimes gets needed reform even before the convention vote occurs. Rhode Island has also made another wise choice. To assist the people in deciding whether or not to call a convention, it has provided in the Constitution for creation of this bipartisan preparatory commission. Other states have established similar commissions by statute or by executive order. What do these commissions do? Well, in other states, when you are going to have a convention, what the commissions do is they engage in major research with regard to the problems that exist, with regard to how other states have addressed themselves to those problems, and assess the success or failure of those approaches adopted in other states. Sometimes these commissions produce voluminous reports. Before the 1963 convention, I believe it was, in Michigan, the commission produced 4 volumes, each of which looked like a telephone book with commentary and analysis. But this is all to the good. There's considerable evidence that these commission materials play a major role in assisting delegates in developing solutions to the state's problems and voters in deciding whether to call a convention or to endorse the convention's handiwork as well. The people's representatives also get to make some important choices. In most states, the legislature establishes the system of delegate selection, determining how many delegates there will be and the constituencies from which they will be selected. Most states, like Rhode Island, use legislative districts for selecting delegates in order to avoid legal challenges under the Voting Rights Act or under the Supreme Court's one-person, one-vote standard. State legislatures, again, in most states, Rhode Island here an exception because they've constitutionalized it, can schedule delegate selection to occur simultaneous with the vote on whether to have a convention or to have it occur after the decision has been made to have a convention. Rhode Island has chosen, of course, the latter approach. The former approach, simultaneous selection, can result in a great deal of wasted energy. You campaign to become a delegate, and there's no convention. You're elected for the party, but the party's been canceled. On the other hand, the advantage of the simultaneous selection is usually there's a great deal of turnout. If you have a special election, turnout tends to be low, and those who are selecting the delegates may be a unrepresentative sample of the population. Most states also determine whether the convention delegates will be selected in a partisan or a nonpartisan election. If one chooses to select delegates in a partisan election, this obviously enhances party control over who gets chosen, and typically the conventions, when they're formed, organize themselves along partisan lines the same way you would find a state legislature organized. This also means typically that the partisan composition of the convention reflects the partisan composition or tends to be similar to the partisan composition of the state legislature. If you don't have partisan election and have real nonpartisan election in which the parties don't dominate, you get a different delegate mix. sometimes with happy results, sometimes with not happy results. In Maryland in 1967, for example, candidates ran without party labels and without much party input into who was running. The result was a convention dominated by political amateurs. They produced a constitution that political reformers rejoiced in, and they lost by about 2-1 vote in the ratification vote. How you choose the delegates determines to a considerable extent how the convention will operate and the sorts of proposals that will emanate. A final choice, and this is, I think, a crucial choice, addressed by state constitutions in some states and by statutes in others, involves eligibility to serve as a convention delegate. Some states impose the same eligibility requirements as for state legislators. Other states permit all eligible voters to serve as delegates. Whichever of those choices is made is not likely to have a crucial effect. But what may have a crucial effect, some states, either by constitutional provision or by statute, prohibit any person from simultaneously holding more than one state office. In at least some states, this has been interpreted to mean that if you are serving as a legislator or a mayor or a official within the executive branch, you cannot simultaneously serve as a delegate. If you wish to serve as a delegate, you will have to resign your post. Most state office holders are understandably reluctant to do so because being a convention delegate is a temporary job and because the job that they're vacating may not be available to them when the convention is over. The effect of a ban on dual office holding, thus, is to prevent leading political figures in the state from serving as delegates. This has both positive and negative consequences. The negative is that the convention loses the political experience and leadership skills of those serving in state office. Although in many states that have this, former legislators and former governors do serve in conventions. But from my point of view, the positives actually outnumber the negatives here. One positive is that the opportunity is available for a whole new group of individuals to play a part in the politics of the state. Montana in 1971, when they had their convention, had this ban on dual office holding. At the time of the convention, the Montana legislature had 4 women in the entire legislature. Legislators not able to serve, of the 100 delegates at the Montana convention, 19 of them were women. Opportunities became available. Another positive is the new perspectives that these delegates bring to issues confronting the state. Delegates serve for only a limited period of time. They don't have to worry about re-election. If they have not served in government, and many of them have not, they are not wedded to the way things have been done in the past. And because they don't have to worry about the short-term political consequences of their actions, they can bring a different perspective to the issues they confront, thinking not in terms of the next election, but perhaps the next generation or the generations after that. I got a signal that my time is short, so let me just make a couple comments about what happens within the... Don't listen to that? Well, I saw people walking out. I thought that was a perfect indication. It's only 20.
Sorry.
Within the convention itself, again, important choices. The delegates choose how to structure the convention, how the work will be organized, and how it will be accomplished. They choose who will preside over the convention, and they create the convention's committee system. And committees in constitutional conventions, given the short time frame within which conventions usually operate, are crucially important. With regard to leadership of the convention, the delegates may choose a person of stature who's seen as above politics. Think of the selection of George Washington, the Philadelphia Convention of 1787. Or the delegates may choose as president, the leader of the majority party in the convention. If this latter course is adopted, the convention may well operate like a state legislature with. He has a different watch than you do. The last point I will say, though, is that going back to what happened in the 1986 convention, you notice that there were 14 separate proposals put forth to the voters. This choice as to how the handiwork of the convention will be submitted to the voters is a matter that the delegates decide themselves. The advantage of multiple submissions like this is that if there is a controversial issue or two, you don't want that to sink the entire Constitution. Separate submission has the opportunity, therefore, to separate the controversial from the non-controversial and allow progress to be made. You notice that almost all the examples I've used have related to conventions, 1970s, 1960s. That's because, as was noted, Rhode Island is the last state to have had a convention. In part, reflects a view that conventions are expensive, which they can be. In part, it reflects a suspicion that the same folks who dominate ordinary politics in the state will dominate politics in the convention as well. And in part, it may just be an interest in piecemeal change through amendment rather than more comprehensive change. But this piecemeal change isn't altogether satisfactory oftentimes. Sometimes a state's problems require more comprehensive solution that upsets the status quo. And sometimes it may even be worthwhile simply to change the political dynamics in the state. As a supporter of constitutional reform in Louisiana once said, if it ain't broke, break it. Whether there's a need for this within Rhode Island, I leave to you, but I hope the discussion is helpful in making that decision. Thank you very much.
Thank you. I'd like to thank our panelists. We're going to take a quick break. Be back here in your seats ready to go at 10:30. And please remember there are postcards outside in the hallway. Please submit your questions with your name in writing to myself or one of the volunteers at the event. Thank you.